Good afternoon, everyone. Thank you for taking the time out of your busy day to be with us for an hour today. I think you are in for a real treat. Sherri Dozier and Jeannine Lewis are leading today's training on benefit provision and notices from an audit perspective. They both have a claims background with a combined 70+ years of experience. Sherri is an audit expert and clients regularly utilize her skills to assist with audit preparation. Jeannine is an ADR expert and clients utilize her knowledge to assist with mediations and arbitrations and setting up new ADR programs. And speaking of a claims background, we have Ryan Alves from our Sacramento office joining. He's going to help with questions today. And prior to becoming an attorney and during law school, he was a workers' comp claims adjuster. He has been with us for 10 years today. So happy anniversary to Ryan. We also have David Majubi from our Anaheim office and Kim Newton out of LA joining. They're going to say hi in just a moment. But before that, I want to share a little bit about our value-added services. Consider following us on our LinkedIn and other social media platforms so you don't miss out on breaking workers' compensation news, new blog articles, upcoming webinars, and much, much more. Speaking of blogs, have you checked out our blog? We typically release an article or more a week. And there's a lot of really valuable information in there. I highly recommend you check it out. And have you heard about our rating department? The department fully analyzes and annotates reports shortcomings, outlining sections that either need to be bolstered or undercut, depending on the client's objectives. Do you need additional CE credits? I know your credits are due this month. We have over 50 videos for viewing on our website, and we really do have, we might be over 60 now. And you can view those videos at bradfordbarthel.com. Go to our education section and then click on webinars. You can also find today's webinar information on that page, along with a link to today's PowerPoint presentation. I will also share that link in the chat function during today's webinar. All the information I just talked about, the blog, social media links, the rating department, it can all be found on our website at bradfordbarthel.com. Okay, I think I've talked enough for today. David, would you like to start us off with introductions?
Sure, thank you, Tammy. My name's David Majubi. I'm a partner here in our Anaheim office, and I've been with Bradford and Barthel now for 10 years also. Our office typically handles from Long Beach to Orange County, but as you all know, due to COVID, we have opened up our coverage so that attorneys can handle just about anywhere in the state. I handle all aspects of workers' compensation defense claims. I do have a specialty with liens. And if any of you do have non-IBR petitions that come your way or unruly lien claimants, I would look forward to working with you in that regard. So with that, I will hand it off to Kim, another associate here at B&B.
Thank you, David. Yes, my name is Kim Newton. I'm an associate here out of the Los Angeles office. I handle an array of types of cases, but my background is handling delivery drivers, warehouse workers, retail workers, police and safety workers. I enjoy running. I'm a foodie. I love the Investigation Discovery Channel. So just remember about me, I love settling cases. That's my main thing. My middle name should be settle, where it's appropriate. But I'm really good at it. I love what I do. I love being at Bradford and Barthel, and thank you for being here today.
All right. Good morning, everybody. I don't think Tammy left anything for me to say. My name is Ryan Alves. I'm a senior partner with the firm. I've been here for 10 years. Before that, I was an adjuster for 7 years at Liberty Mutual. I'm based here out of the Sacramento office. Thank you, everybody, so much for your time today. I see a whole bunch of familiar names already. For today's purposes, I will be hanging out in the chat and in the questions. picking out some of the best or the most common questions that we can then append to our experts here today, Sherri and Jeannine. And so without further ado, we'll hand everybody off to Jeannine.
Hi, everybody. Jeannine Lewis from Bradford Barthel. I've been here for 12 years as Director of Marketing, Quality Assurance, ADR, Sports Marketing, kind of the niche director on the specialty lines. Prior to that, I was Claims Manager and Director for a number of insurance companies for, let's say, 5 years in Dog's life, so a long time. So thank you for joining us today. I think you'll find it beneficial. We're going to be covering a lot of material, primarily those that kind of hit the audit unit's eyeballs. So with that, I'm going to hang it over to Sherri.
Thanks, Jeannine. Good afternoon, everyone. Thanks so much for joining us. I'm really looking forward to talking to all of you, and I actually look forward to when we can talk in person, and I'd love to have a big group of you and be doing this very thing. So I have been in the industry for 34 years, but with Bradford Barthel long enough to have a couple hairstyle changes and color changes. So figure that one out. No, I've been here nearing my 22nd year, and I specialize in complex cases. And also you can just guess maybe that I also specialize as an audit consultant for the firm. So with that being said, I did want to tell you that Tammy was saying that we'd have the quote at the beginning. We're not going to have it at the beginning. There's going to be a slide later on in the presentation, but she's exactly right. I'll say the quote, I'll tell you, you're supposed to look at it and answer it, and the first one of you that get it, we're happy to send a really nice prize out to you. Okay, just covering a little more material. B&B has an excellent appellate department. Louis Lars, I go to him for so many things. In fact, I quote him in one of the slides today, but he has hundreds of recons and removals, nearly 100 writs of review, over a dozen Supreme Court petitions for review. So keep them in mind if you have a really complex situation going on and you really need getting prepared for to determine whether you want to appeal a decision or remove it. Keep Louis in mind. He's great. You've seen that and you've seen me. See, there's the hair, different color. Okay, and we move on. All right, so let us jump right into this. In 2021, the audit program description for the California Division of Workers' Compensation starts off like this. The guiding labor codes are 129.5, and the audit and enforcement unit is required to conduct a routine audit, profile audit review, we'll call it PAR from now on, in California once every 5 years. And I remember the days when they were called the OBE audit unit.
Sherri, did you want to do polls?
Yeah, Tammy, you know what? Let's start off with the polls. I do want to get to know you and where each of you have, if you've had experience. So let's see what the polls say. Go ahead, Tammy.
I've already put the first one on the screen here, and you guys are already answering. Thank you. And the question is, have you received an audit notice either late last year or during this year? And I'm just going to give it a few more seconds. You guys are voting pretty quickly. We have about 5 of these, so we're going to run through them. And I'm going to move on in about 3 seconds. And I'm going to share the results just so you can all see. And Sherri, the results on that, 62% no, they have not. 38% yes.
Wow, interesting.
Second poll question is popping up on your screen now. Have you received an audit commencement notice? Again, either late last year or during this year. And thank you so much. As Sherri was saying, this gives them an idea of where you're at. At this point, Sherri, almost all of them are saying no, they have not. So I'm going to give it 3 more seconds. And I'm going to share these results real quick. 80% say no.
Fascinating. This stuff is for you guys then, I'm telling you. You need to know. So this is great information. Go ahead, Tammy.
Third question, have you been through a PAR, a profile audit review in the last 5 years? So have you been through a profile audit review in the last 5 years? So some people are answering on the question section, which is absolutely fine. I'm getting a lot of no's on that one, on this one. And I'm going to go ahead and close this in 3 seconds. I'm going to share these results. So 60% say yes, Sherri.
Okay.
Okay.
Well, we promise we're not going to sell this list to the audit unit, so they can
Exactly.
put your mind at ease.
Okay, same kind of question, but we're doing with more than 5 years. So have you been through a PAR more than 5 years ago? So a profile audit review. Yeah, we're not turning this in. Good point, Jeannine. And you guys are really good at this. So I'm going to give it 3 more seconds. Okay, and then here's the results for this one. 63% say yes and 37% say no. Final poll question. Have you been through a full compliance audit, which is, called an FCA? Your options are yes and you passed, yes and you failed, or no. So three options this time. Okay, 3 seconds. And these are some good numbers, Sherri. So 36% say yes and passed, 7% say yes and failed, and no for 58%.
Right.
Heart aches for those who fail, and they're going to know a lot of the things that we're talking about as we go through the presentation. I also wanted to say thank you so much for participating in that. It really does give us a good baseline for what we're talking about, and knowing that you guys really need to hear the same information. And I did want to say, auditors are people too. Somebody in the audience is maybe married to an auditor, has a relative who is an auditor, maybe has a really good friend. And what I would say to you is, just like during the holidays, we love you, but we don't always have to agree with you, okay? And so for that, we will move on. All right, subjects of audits are rated on measurements standards set by the prior audit results in the industry. And the administrator director annually establishes the profile audit review and the full compliance audit standards. So the 2021 standards were supposed to be based on the calendar years of 2017 through 2019. And the clients that I've been working with have told me that they have dropped off the year 2017 and added 2020. And in the question section, this is just for my own knowledge, if any of you who have been notified have a different experience where you're getting 2017 audited, please let me know. I'm curious to see if this is just across the board where they're going, or if this is something just for the particular clients that I'm working with right now. So under Rule 8 CCR 101.071C, the goal in a profile audit review, they schedule selection of files and alternates to look at, and the percentage for this 2021 year is 1.46656. You must be at that or under that to pass PAR. So what happens if you pass PAR? You will be required to pay all the compensation due, but in this case, no administrative penalties will be assessed. So folks, this is the goal. We want to pass PAR. And here's the other best news about this is the audit unit goes away for 5 years. So under 8 CCR 101.071D, what is the goal for a full compliance audit? It's just merely an expanded review of additional files. And based on the audit results from that full sample of indemnity claims, the total percentage, that includes the PAR audit percentage, is 1.85379. And no, you don't get to combine the two to make your percentage. You have the 1.85379 is the full percentage for both the PAR and when you go into the FCA, what we'll call first stage. So what happens if you pass the FCA? You will be required to pay any paid compensation, and here's where the penalties will be assessed, but only for violations involving failure to pay indemnity or late paid indemnity. The unfortunate part, though, is the audit enforcement unit comes back again in 2 years. So this is where we don't want to be, and some of you in the poll had said you've unfortunately been here, and you know what I'm talking about. They can come back before 2 years, but it's within 2 years. So, if you fail, then you go to the FCA2. This is the final phase, and it's under 8 CCR 10107.1 and so on. And this one, they include review of all issues, including but not limited to denied cases. And this is a situation where back early in the day, Tom Bradford said, yes, Sherri, you can help a friend through an audit. And we had a limited number of files, but we ended up where on 26 files, we ended up having a $1.2 million penalty. And yes, that's a true story. So I learned a lot from that, and that's carried me through the years. And I continue learning about audits and what happens in audits. And I'm going to say this is where we have our you can win a prize. I'm going to read, and please answer in the questions. And the first one who puts the answer in, I'm trying to give you time here. An ounce of prevention is worth a pound of cure. Okay, who said that? So the time clock is ticking. I'd sing to you, but maybe that would offend some. Jeopardy
Sherri,
music.
I think the first person to get it correct, because it was Christine Neufer. I'm not sure if I'm saying it right. Neufer. She was the first person to answer correctly with Benjamin Franklin, right?
Awesome. Benjamin Franklin is the answer. Famously advised the fire-threatened Philadelphians in 1736 that an ounce of prevention is worth a pound of cure. And clearly, preventing fires on your files before an audit is better than having to fight them during an audit. Bum, bum, bum. We all agree on that. Thank you for participating, Christine. And I think you're from Instar, if I'm not mistaken.
She is.
Good. So great job. What happens if you pass the FCA? You will be required to pay unpaid compensation penalties assessed for all violations. The penalty scale on this one escalates depending on the frequency and the severity of the infraction. And there are a wide variety of considerations at this stage of the audit, which include but are not limited to business practice. On that audit I told you about early on, that's what happened. It was a business practice. Business practice penalties are extremely serious, and they can be up to $400,000 plus the individual penalties for the individual violations. So we don't want to be here. So let's do the ounce of prevention to help our cure, right? That's what we want to do. Okay, so we think we know what's in our files, but do we? I've looked at literally thousands of files now, and I recommend you consider a pre-audit or a mock audit if you know your numbers coming up in the next year. Claims really can be complex and disputes do arise, and your main role as an administrator is to provide the benefits that are due. That's always your dilemma. So my food for thought: if you do not have in your possession documentation to support a dispute that you owe, then pay benefits that you owe until you can obtain the documents that support your dispute. In other words, pay what you owe until you have the documentation. Your arguments are always more persuasive when you have the proof. So what categories are included in a PAR audit? Frequency of claims with unpaid compensation and the amount. Frequency of claims with violations involving late temporary disability payments or first notices of salary continuation. We will be covering salary continuation, and that is an area right now of concern, kind of a little red flag for you to pay attention to in the future. Maybe go back through your files on any of your employers that are talking about having salary continuation, especially on the COVID cases now that 2020 is involved. Frequency of claims with violations involving late payments on permanent disability or death benefits. Frequency of claims with violations involving the subsequent schedules, indemnity payments. And the final one, the percentage of claims that do not properly give the benefit of AME, QME, and And one thing I also see is you have to make sure that you say in your enclosures what you're sending and then maintain a copy in your file. So let's talk about practicing the process. I know we all thought we were getting over COVID-19, and your practices during COVID-19 are going to be reviewed in 2020 and are subject to audit review. So what possibly could go wrong, right? So this is a dilemma that I think we all faced as we were going through the COVID cases, and we asked, you know, a lot of our attorneys who are COVID specialists were asked this question, and we had roundtables and discussions with you clients, and we've come up with some things. And also I've had the privilege of working with a few clients that have had auditors actually say certain things to them. So let's go through this process and then we'll talk about that on the other side. So do we owe temporary disability when an employer who was offering modified has to be closed or lays off due to a mandatory order of loss of business because of COVID? And the answer really lies, firstly, and there's other cases as well, but in Bethlehem Steel. And it's an old industrial accident case. And the WCAB was cited, and it said, for the purpose of once an injured worker has returned to work unrestricted duties, they are no longer temporarily totally disabled. Then there's the Young case. When an employee is offered modified duty, and they refuse that modified duty, then they are no longer temporarily totally disabled. So the question that I ask myself, are the employees released to full duty as in Bethlehem Steel? And really the answer in the COVID cases are no. If on modified duty, they have not been released to full duty. Is modified duty being offered as in Young? Answer is, in Young, the employees must receive an offer and then refuse it. In the current circumstance, modified duty is not being offered because of COVID-19. The employee is not refusing to accept the modified duty. And certainly this is not due to anything that as to your fault, but it still remains in a difficult circumstance. How do we follow the laws that exist? So here's some audit unit insight. And this is something a client was faced with, and they brought me into it, and I'm happy to share it with all of you. No names being named, but it's really good insight for the industry at large to understand. If there is medical evidence, now we're talking medical reports that says someone is still temporarily disabled in a COVID-19 case, then what they're recommending is for you to send a TD start notice and explain that the employer picked up that sick pay leave that was required early on. And then if there's continued benefits, then you pick up the temporary disability. Now, as we know, the vast majority of the COVID cases do not have any medicals. They just have a positive test result and no other medicals. In those cases, from what the audit unit was saying in their perspective, it's okay to send a TD denial. Now, if you use salary continuation notices, and I have to say early on, I thought that was the way to go because it made sense that the employer was paying benefits. That was not the ultimate consensus. And we actually followed, Bradford Barthel followed along with the two guidelines above. So you must have documentation in your file of the employee salary continuation program. So those employers who are saying that they have salary continuation or going to do salary continuations need to have a program. And just a little bit later, we're going to cover the codes that make that requirement. So here's some more information from some audit notes, okay? At this time, the DWC has no authority to suspend our statutory or regulatory provisions. Our authority, the audit unit, is based on Labor Code 129.5 and the California Code and regulations. The DWC will certainly consider all relevant and mitigating facts. So here's where I'm going to tell you, please document your files. All relevant facts are very important here, and you have many different circumstances on your cases. So when considering a deadline that may have been missed due to compliance with either COVID-19 mandate, stay in shelter order, some guideline issued by the state or federal agency, or prior to assessing an administrative penalty for a violation that you would contribute to COVID-19, The affected party, which is you, should be sure to document all shutdowns, office closures, or public mandate guidelines as evidence of an actual impact. So again, document when your employer had to shut down, what was going on, what you had to do in relationship to that to support your position. Now, at this point, I just want to remind you, there are no regulations that guide what benefit notices you have to send out. So this is just some food for thought by the audit unit on a general and global basis as to what they're going to do. It appears as if they're going to try to take all considerations into account when looking at the COVID cases. PwC has no authority to advise a workers' compensation appeals board on a course of action should a COVID-19 issue be brought before them. So if a benefit is due, the benefit would still have to be paid and the proper notice sent out. And if they were paid salary continuation, TD is not due. If temporary disability was determined to be delayed or disputed, then you would have to provide the documentation on the delay or denial. And that would be your obligation even if it wasn't a COVID case. So let's start with the first one, and it's a benefit notice regulation overview. And 9812 is something that another client brought to my attention, and there's a specific part of this that I'm going to bring your attention to, and I want you, as you're looking through your files and looking through the benefit notices that you've provided, to make sure you're accurate. So benefit payments and notices, this is kind of the guideline when they're due and what notices are required. For temporary disability, it's due 14 days from the date of the employer knowledge, and consider medical evidence as notice and any source of medical evidence. A notice is due to the injured worker for delay payments, when you make a payment, or if you deny a payment. An example might be you received an applicant's medical indicating TD was due. You have to address the medical, even with a delay, or if you have contrary evidence where your person's treating with an MPN doctor, PTP, and that doctor says modified and your employer is providing it, then you may, in that particular case, decide to deny temporary disability benefits. That's going to be a case-by-case basis and a choice. But every medical, and the point being, every medical is to be considered and you have to take action. So there are many different fact patterns and you have to work through each one. So here's the slide that I'm really going to emphasize a portion of it. And this is the labor code that was cited for one of our friends in the industry that was going through an audit. It's 9812D. And D says the notice that benefits are ending temporary disability or permanent disability at the same time a payment of temporary disability and then or permanent disability, and then a claims examiner has to advise the employee of the ending of the benefits. They have to do a full accounting of the compensation paid. They have to give reasons for that, and they also have to include the time frames, the total amount paid, and if they did pay penalties. And we pretty much know all that. If a decision to end temporary disability indemnity is made on the medical on a medical report, that medical report shall be provided. Except for psychiatric reports, a lot of them say on the surface of it, please don't provide this to the injured worker. That's the part I want to emphasize. When you end a temporary disability or permanent disability benefit, a medical needs to be sent if it's for a medical reason. Mostly on permanent disability, it ends because the medical that you already sent to them says that's the payments that we're going to make to you. So it kind of makes sense, right? So if claims administrators determine that it's based on medical, a copy of the medical needs to be placed. And then if it's a psychiatric medical, we don't do it if it says not to send it to the injured worker. But 9811 does not give a clear definition of what constitutes a medical. So I haven't seen this a lot from the auditors where they're really enforcing the medicals being sent if the medicals are less than a medical report. So what if an auditor finds a violation of 9812D? You failed to send a copy of a return to work slip. Now, you know, what I ask myself is, well, doesn't the copy of the return to work slip come from the injured worker to the employer and the employer to us? And normally that's how that happens. So I went ahead and I asked our appellate wizard, Louis Lars, how he interpreted that law. And what he said was this: the direct interpretation as he reads it is when a medical reason is used to end benefits, then a medical, even if it's only a medical slip, needs to be sent out to the injured worker, and if they're represented, their attorney. So the strict interpretation of the law is that you send the medical, or in the case of a medical return to work slip, that slip. Now, that wasn't in the past, as I said, something I saw practiced regularly, but if we're going to strictly interpret what the labor code says, what the rule says, then let's do that. And just be aware of that, that's something in the current audits that's being utilized. So the moral of the story, what did we learn here? If you're ending a benefit due to a medical reason, then you're going to send even a slip of paper that says they can return to work. And again, not something I have seen focused on in the past. So here's another biggie, and I alluded to that earlier, 9814 salary continuation. Employers should have an established program, and the notice is due from the employer, but it's actually from you, the date of knowledge of injury and evidence from any source for losing time due to the injury. This is another area that has caught our attention, and it is a focus of the audit unit. I've heard there's an expectation for all of you to maintain a copy of the employer's written salary continuation program in your file. Now, I examined many years, and maybe even Jeannine, if you want to jump in on this, have you heard the auditors or of us being required to keep a copy of the salary continuation program in our files? I've not heard of that.
The last DWC conference, the DWC AD made reference to this, and he indicated that, you know, it has been in the benefit notices, benefit notice manual since 2016, but it really hasn't been a hot button for the audit unit. So now that they have things to do, it has caught their eye, it's given them another opportunity for hunting. So it does state in the beginning TD notice that salary continuation information needs to be provided. It doesn't say you have to attach a copy of the actual human resource guide referencing that, but it does state that you need to document clearly what the employer's return to work policy is. But he did state that possibly giving a URL to the human resource manual would be helpful, but not keeping a copy of it in the file was actually mandatory, but a good written summary of what it was mandatory.
And thanks, Jeannine. That's a great an additional insight. And I've actually heard from an auditor that they were requiring or suggesting or recommending. And anytime they suggest, I take that almost as a requirement or what they're going to interpret it as. They were saying they wanted to see a copy of the policy, the program, inside the file.
Then let's do it. That's, I mean, if you hear that, I think that's giving us some additional direction and more ammunition to fight back for it. So if we can get our hands on that policy, put it in your file.
I would ask for it anytime you can, or I would get something in writing from your employer to say, here's our policy. Keep in mind, your policyholders and your employers, they really do have to apply it equally among all people. So they should have some kind of practice, whether it's I'm going to provide the first week, I'm going to provide the first 2 weeks, or I'll go ahead and do salary continuation for a period of 4 weeks or whatever time frame they choose. But they should apply that across the board. So they should have a pattern and practice, so to speak.
Yeah, and salary continuation isn't going to apply to each and every case.
It won't.
There's just a handful of types of occupations that they may offer that for. So it's not going to be a huge burden to do it, but I would say let's do it.
And it may be different in the COVID-19, the 2020 cases. And so in your 2020 cases, if you want to take a preview of them and see how you made your decisions and what notices you did send out, you may want to look at gathering the information on those cases. If you did decide to send out a salary continuation, that you actually have a policy or something in writing from your employer to say, here's our policy, here's our practice.
And wink, wink, it's not going to do you any damage to go back and get that information now and send out an amended notice you'll have it in your file, and it'll protect you from those OBIs or audit unit I's if and when they do come in.
Exactly. Totally agree. So, in relation to periods of temporary disability, and we kind of covered this already, find out if they have a policy, get something in writing, and put it in your file, just to support those few that do end up having a salary continuation situation. And I would always ask in your initial contact, do you have a salary continuation program? And then you'll kind of know what you're looking for.
Yeah.
So 9815, correction notices. And this is where I see through all the files that I've reviewed, sometimes we will take a corrective action. We'll make up for a mistake that maybe we made when we're looking through our files, but we're not sending the notices. So a corrective notice is at any time during the file, really, but applies to subsequent notices, and they're due 14 days from your knowledge of an error. And let's say even a change in the wage, you get a wage statement and you do the wage statement calculation and you determine that, okay, now I owe more money. You owe a correction notice at that point. And Jeannine, I think you're going to cover this information.
I am. Thanks, Sherri. Just keep in mind that employer date of knowledge is always going to be that 14-day time flag for issuing your disability notices, for your delay, you're issuing your payment notices for any species of benefit. That's the TD, PD, paying partial wage loss. Any of those are going to be controlled by that 14 days. Your TD delay is 14 days from the employer's knowledge, and it must include all the remedies. And we're not going to include everything in 9812 because that would be a 3-hour presentation, and I know you guys would be sleeping by then. So I'm going to refer you back again to 9812. Sherri mentioned it earlier as kind of a roadmap. I say it's a little bit like your North Star, your Bible. Keep it on your desk, tattoo it on your forehead, because that is something that you need to have at your desk and know all the time when your benefits are due. Because there is a track for represented injured workers and unrepresented injured workers. So be sure that you're on that correct track when you're issuing these notices. Your TD decision that you are giving in these notices, be sure you're using the correct date and refer back to that date in any of your disability notices. You may issue a delay notice, but be sure that if you're issuing a redelay, be sure it's done before that delay date. So you don't want to miss it. If you give June 24th as that date, don't do it on June 28th because you'll be late. Okay. TD start notices are, again, you're going to initiate that TD 14 days from date of knowledge of any source. TD end or stop notice, again, it's 14 days from the date that TD ended based on medical evidence. And you're going to have another track if you're going to be confirming that the injured worker has returned to work in a full capacity or modified work. And you may have some supplemental job displacement notices that may start to initiate at that point in time. TD end or stop notices, you need to address PD. At that time, you might not know. You might not have the correct information yet for medical. So you may want to delay or defer that opinion until you get that medical evidence. And again, just like in the TD, you can redelay or modify that date, but you can't miss it, or you might have an administrative penalty. So be sure you keep an eye on those delay dates. PD monitoring or PD deferred, again, is 14 days from the date that the employer is providing information on a permanent, alternate, or regular work. This notice can follow up by another PD delay notice or your deferral notice. So just keep an eye on which one you're sending, and I'll refer you back again to 9812 to see which track you're going to use there. If you're starting PD, remember, it's 14 days from the date that medical evidence came in, and you'll need to send a copy of that medical report and the information about how much you believe you're going to be paying, and include a string notice, string rating. And if you need assistance with that, Tammy already told you about our superior rating department. We can help you with those ratings to help you with getting your advances in the impairment correct. Represented cases, we want to advance up to 85% so you don't overpay. And non-represented injured workers, let's pay it up to 100% of those rated estimates.
And I have to say, Jeannine, that some of the files I've looked at, people will pick a number. I'm gonna give 5%, and I'm gonna advance 5%. And you really need to do a string rating and make sure you have an accurate understanding of what benefits you owe and when you owe them. So keep that in mind. Don't just pick an arbitrary number.
Yeah. If you know the injured workers had surgery, you know that they're going to have some type of impairment. Whether they're complaining about it or not, the doctor's going to find something, or the judge will find something.
And if you know they have a standard disability, for example, let's use the example of a knee injury where they had surgery for medial and lateral meniscus, you know there's a standard 4% rating. So you need to pay attention to those kind of things, so that even if the injured worker somewhere down the line doesn't cooperate, or you can't get them to go forward on something, that you're still advancing what you owe.
But the audit unit does want to see your string rating. So be sure it's there, and put that in your file notes as well. PD denials, again, are due 14 days from the date the medical evidence from any source. And I would always recommend that you document when you receive that medical report. PD denial should include the appropriate remedies to address the QME process on the non-represented and represented track. So if you have any questions on that, refer back to 9812, or give Sherri or myself a call, and we can assist you with that particular track that you're on. Hopefully your system does document electronically the date that you received that particular piece of mail, because it is important that the audit unit sees when you received it, so that they could base the promptness of your decision. And make sure that medical report is sent to the injured worker, unless it is a psychiatric report that the doctor already told you not to release. And there will be times when you have different start and stop dates. Don't be surprised if you have the injured worker tries to go back to work, you stop TD, you delay PD, he can't work, so he's off work again, so you have to start PD. That's the life we live. So don't be surprised if you have multiple notices to send. And benefit notices are all due with starts and stops and change. So every time there's an event, you have to react to it. So just think an indemnity benefit triggers a notice. So always be sure of that. Wage statements will change the benefit rate due within 14 days from the date of knowledge of that rate increase or decrease. So be sure that you're calculating your wage statement. You want to either run a tape or put the information on that wage statement, put it in your file notes on how you did calculate that wage statement. If the rate is a decrease, or you feel that the injured worker is making less based on the wage statement, always go back and look at the 50/20. Because again, we're always looking at earning capacity, what the injured worker was hired to do, at what salary he was promised to make. And we're going to probably recommend that you pay the higher of the two. Supplemental job displacement benefits for dates of injury 2013 and forward. If the injured party has PD and the employer cannot offer regular, modified, or alternative work within 60 days from receipt of the claim administrator's physician's return to work voucher report, that's a mouthful, you know you're going to have to pay that $6,000. We know that. And that voucher is due within 20 calendar days from the expiration of the time to make that offer. Keep in mind that it has to be a bona fide job. You just can't pull it out of the air and make it up, and he's going to stand out in front and wave to people. It has to be a bona fide job. and it can't be less than 85% of the earnings prior to the injury, and it has to last 12 months. So we got to keep it real, make it a real job for them. Sherri.
So it's me again. Okay, so let's talk about waiting period. If a waiting period was taken, then it's due in the next check and no later than the 28th day. You never hold a waiting period for those that are hospitalized. But if you know someone's going to be off more than 14 days, you are not required to hold back that waiting period. I mean, this is not EDD, folks. We don't take 7 days and then not pay it later. The waiting periods in work comp are fluid and not absolute, other than if you don't pay them and they're due, then you're going to get a penalty. So wage loss. 4654 temporary partial disability is 2/3 of the weekly loss in wages. And this usually happens if a doctor returns someone to work and the employer can't accommodate their full work restriction, or they have an offsite program, they're paying salary continuation but not the full salary, or if they reduce a rate of pay because they're working a different job. So you may owe wage loss. You will need to know the injured worker's average weekly wage. It's always capped at the maximum or minimum, and the date of injury, and the current rate and hours worked. Using 2 times and divided by 3, you're going to get your wage loss benefit. So that sounds really simple. So here are the 4 questions. What is the injured worker average weekly wage? How many hours can the injured worker work? And what does the PTP say? Or did your employer reduce the hours or the rate of pay per the PTP or QME? What commitment, and this is the big one, the take home that I want you to get from this. What commitment can your employer make regarding weekly hours and the rate? Get a number and make them stick to it. Document it in your file. Really, this is where the audit unit wants to see a consistent 14-day, every 2 week, just like you're paying regular normal benefits. And then when the employer then sends you the proof, because you still need the proof, and there is an alteration in that proof, then you deal with that and you send out your change of benefit notice or whatever document you need to send if you have to pay a little more money to the injured worker because you have to recalculate the wage loss. But the thing that you're doing is you're paying timely benefits, and you're timely then responding after you receive the information. You have 14 days to respond to the information an employer sends you to make that change, okay? And the final question is, what benefit notice do I send? So here's an example. We have an injured worker, their average weekly wage is $750 per week, and they work 40 hours per week at the date of injury. You've proven it, you have a wage statement calculation, or you have something, a 50/20 from the employer, or last resort, you have, injured worker check stubs. It's not a reliable source, but at least it's something. But you know that you consider the average weekly wage $750. PTP says injured worker can return to work, but only for 20 hours a week. Or if you take their hourly rate times the 20 hours, that's a loss or reduction of $375. So let's do some math. 750 as an average weekly wage minus the 375 in hours worked, that leaves you with $375 as a difference. And here's where you apply the formula. You take the 375 times 2 and divided by 3, and you have a wage loss of $250 per week. And if you've calculated the wage loss, you owe a temporary partial disability notice, or TPD notice. The audit unit, and I'm going to reiterate this because it's worth saying again, they want to see the cycle of payments in a wage loss situation. And the lack of cooperation by your employer doesn't alleviate your responsibility. That means every 14 days that your injured worker's hours or rate is reduced, and you have to have an understanding of what you owe them and get a check out.
Again,
and a notice always accomplishes.
To that date, if you can't get a hold of your employer, like Sherri said, you got to pay it at that consistent rate, or that they will tag you for it.
They will. So, and if you owe a self-imposed penalty, You have to pay it even if it's the employer's fault. And I know there's a way that you can put it back on your employer. So, but just keep in mind, every 14 days you're issuing a check, and really pin down your employer and document what they said. I think I can give them 10 hours. I think I can give them 20 hours. And let them know that they need to be consistent in that work. That's going to help you pay correct benefits. So kind of moving on, we'll go through this. Cap TD payments, Labor Code 4656. It depends on the date of injury. Date of injuries on or after 4/19/04 and before 1/1/08. And some of you still may have some of these files. It is 104 weeks in a period of 2 years from the first payment of temporary disability. That was kind of just an odd time, wasn't it? Important to note for payments before 1/1/08, if your temporary disability did not start until a year after the temporary disability and payments are made retroactive to the date to the applicant, is still entitled to the full 104 weeks compensable weeks. That usually happen in disputed cases where you owed retroactive. It later on comes to find out that you owe the retroactive money because the doctor said so. And that has to do with the Hawkins case. So fortunately, we're mostly past that, I would say, but you probably still have some cases out there. And if EDD paid, you can't automatically take credit for EDD. You need to have that resolved. And then now in current times, you have to petition to take a credit for EDD. So date of injury on or after 1/1/08 up to 104 weeks in a period of 5 years from the date of injury. So that's where we stand now. So state average weekly wage saw date of injury on or after 1/1/07 each January thereafter to be increased by an amount equal to a percentage to the state average weekly wage. I don't know if any of you know about CalPERS, something to do with some state organizations, unions. They will increase their employees' yearly amount by the state average weekly wage. So in this particular situation, we're mandatorily required to apply state average weekly wage SAW to permanent total disability, permanent partial disability with life pension cases of 70% and above. So 2-year rules, something that sometimes slips by us, that's a Hofmeister case. And just make sure that you're paying the correct amount. 4661.5 2-year rule provides any compensation paid 2 years or later from the date of injury must be given consideration for the rates at the time the payment's being made, unless we're going to decrease the rate. So normally that just applies to injured workers that on the date of injury, they would have received a higher rate because their earning capacity was so much higher. You need to consider that. So you don't want to get caught up in that in an audit where you fail to look at the 2-year potential increase. What does the audit unit want to see in their file documentation? That's actually covered in Insurance Code 1010.1J. 50/20 is required, and some of the files I've reviewed don't have the 50/20. So that's a state, that's forms actually even sent to the state of California. So make sure you have the 50/20 in your file. Wage statement with a tape, and of course we know we're mostly paperless, so most companies that I know. So some companies have a sticker or a sticky that they can put on there. Some companies just have their people document really well in their file notes exactly the periods that they're paying. So always an explanation of remuneration, such as room and board, overtime. Sometimes that information won't be put on the wage statement. So make sure in your initial contact you ask, for example, an apartment manager who gets compensated, or a part of their compensation as the free rent or reduced amount of their rent. And remember, it's always fair market value. So ask your employers who may have employees that monitor the grounds or live in the apartments and they get that as part of their compensation. What is the fair market value of what you're supplying them? You have to make really a lot of good faith attempts to gather the information, not just a one and done, as I call it. You don't document just one time in your file, hey, I asked the employer one time for this information. You really need to pursue it because you need it. And all of this information applies for seasonal workers too. Don't forget 2 or more employers. And I've seen some mistakes on that where even in the initial contact, we've had 2 or more employers identified by the injured party, but we didn't follow up and try to find that information. So full-time regular calculations, 44.53, 30 hours or more, 5 days a week. And I like to talk about a base rate. Now, this is not something that the audit unit talks about. This is a creation of my own, and it helps us to come to a more of a common analysis of files. So base rate is simply the hours times the hourly rate, either on the 50/20 or in your initial contact. And a quick example is $12.10 per hour, and they work 40 hours a week. The base rate would be $4.84. The key now is comparing the base rate to the wage statement while only considering earnings at or above the base rate. And so why would we do it that way? It really does allow a real picture of earning capacity, and it considers all the factors of remuneration, overtime, bonuses, and so forth. So what weeks do we include or exclude? And we thought we weren't supposed to skip or have gaps. We include the weeks that are on the employer's promise 50/20 in verbal information and the bonuses. And that's what I like to say. We include the weeks that are the base rate and above. So we document the hourly rate and the hours worked. And we use all the information used: earnings, bonus, remuneration, overtime, consideration. And we divide only by the weeks that are considered. And it'll simplify your decision. What about exceptions? There's always exceptions. I also wanted to point out that keep in mind you have to pay, someone's paying at every 2 weeks. So the base rate would be $9.68. So we're looking for real earning capacity, and the audit unit considers the 50/20, and the rate less than the 50/20 really has to be considered carefully, and a lot of documentation. That's always the key. 2 or more employers. The rate from the employer where the injury occurred. A wage statement from the concurrent employer is really nice, but a lot of times it's not obtainable. And you use the hours, and this is an example. Employee works 40 hours at $11.50 an hour for your employer, injured on the job. He has a second employer, he works 20 hours, and that rate is $13 per hour. This example would cause to add up the second job hours with the first job, multiply them times the injury rate, which would be $11.50 an hour. At straight rate, it's not overtime rate, and your average weekly wage would be $6.90.
Part-time employees see some pride. You always want to ask, about the concurrent employment, and if they are for sure missing that second job, because you could be doing surveillance and you see him out there, shoveling asphalt, but you didn't ask whether he could still do that. So be sure you've covered that, so we don't run into a fraud situation later on.
Exactly. Moving on to part-time, and I know we're nearly out of time right now, but part-time employees, the emphasis on this is just make sure you consider all of the above. Part-time employees still have all that earning capacity to be considered. Signature fruit is a case you want to look at, and specifically provides for the period of work, not to exceed a year, and you look at the history of their work, and they have the obligation to produce the evidence, but you have the obligation to ask the questions. And finally, Argonaut, Montana case is the primary case for us to look at. This really does deal with earning capacity and reflective of why we use the season promise when we're considering wage calculations. And if all of these factors have been considered, then we can consider ending benefits. So thank you so much for joining us. This has been such a pleasure for us. I really hope you got something from this, and I will turn it back over to Tammy.
Thank you, Ryan. Thank you, Sherri and Jeannine. Thank you, David. I hope you all enjoyed the webinar, and thank you for staying on late with us. Have a wonderful rest of your day. Thanks again. Take care, everybody.
Bye, everybody.
Bye, everybody.